Okay, well, welcome everyone. We're just waiting for everyone to sort of virtually file in. So wanted to give some time for those who have registered to get into the room. We're going to get started now. I'm George Constantine. I am chair of the Nonprofit Organizations Practice Group here at Venable. And I want to welcome you to our monthly webinar on regulating conduct and ethics while minimizing legal risk. We have had done a lot of work recently in this area, which seems to have picked up. Many of our nonprofit organization clients, like those of you on the phone, have had instances where members or individuals who attend your events or otherwise people covered under your organization have engaged in activities that may be questionable, and many of our nonprofit clients are becoming more aggressive in enforcing those activities. And obviously, doing so does come with some risks. So we thought this would be a good topic for our August webinar, so we appreciate everyone joining. As I noted, I'm George Constantine. I'm joined by my colleague, Andrew Steinberg, who has been with us at the firm here for 10 years, basically, and has worked in our nonprofit organizations practice that whole time, and does a lot of work, as do I, on just these sorts of things, where we have clients that have formed codes of ethics, codes of conduct, and have started to enforce them. So to advise on how to do that effectively and also in a way that keeps the legal risk low. Andrew is a graduate of University of Maryland and law school, William and Mary, and a great counselor to many of our nonprofit clients. Today, what we plan to do, I'll just at the outset, we'll go through our program pretty much without taking questions during the bulk of our discussion, just because it's kind of difficult to do technologically in a way that's not distracting. So we're going to go through, but there is an opportunity for you to post in the Q&A section questions that you might have. And if we have time at the end, and we may, we'll be able to address those then. And also we will have those archived to be able to get back to you afterwards as well. So we'll start off with, just some general introductory comments about, what the sort of rationale, reasons, benefits, and burdens are of going through a process of regulating conduct of your members, and then talk more specifically about what approaches to take and how to manage legal risk when it comes to setting your ethical standard or maybe revising it. And then we'll go to the procedural side of things. So whenever we work with organizations that have codes of conduct or codes of ethics, I like to sort of point out there's sort of two main documents that we're dealing with here. One is the standard that you're setting, and that is the code of ethics itself. That's the code of conduct we're asking people to adhere to, be it our members or people who attend our events or otherwise people who are covered by the organization. And then secondly, what are the procedures? How are we going to enforce those? How are we going to manage our legal risk, but also do this in an effective and efficient way? So we've divided up this presentation just the same way. You've got your standards and you've got your procedures. And then we'll talk about some general conclusory remarks. Hopefully along the way, given that we do a lot of work with these types of codes and enforcing these codes with so many different organizations, we have picked up a few pointers that might be kind of non-legal, but more practical in terms of how to deal with these codes. So we'll try to share those along the way too. Okay, that's a famous quote attributed to Groucho Marx, which often comes to mind when we talk about enforcing codes of conduct and codes of ethics with nonprofit organizations. What it comes down to, though, really is with so many of our groups that we work with, and so many of you represented on the phone, is how can we refuse someone to be a member or deny someone membership or remove them from membership or refuse them access to a certain activity or programs or otherwise exert sanctions on an individual in a way that has the effect of improving our general reputation and at the same time has the effect of not increasing our legal risk too much. So next slide.
And on the flip side too, in updating your code or creating a code, it's important to get buy-in from the community that's going to be bound by the code. So to encourage compliance with it and have buy-in from those who are going to be enforcing the code and subject to its restrictions as well.
Exactly right. Yeah, we'll talk a little bit about how to do that in a practical way. So why should we care, and what are the legal concerns? I always sort of divide it into sort of two different categories under the why should we care. I can go to the next slide, Dave. I think it's at a very high aspirational level, we want to have a profession, an industry, and a group of people that are within our group that strive to act in the most ethical manner possible. And that we are part of our role as a nonprofit organization, particularly if we're a membership organization, is to one of our roles as a membership organization is to make sure that the members understand the importance of ethics. So very sort of high level, big picture. It's a great thing to do as a nonprofit organization, and also, we want to, for the good of the profession, if we're a professional organization, say a society of doctors or a society of engineers or a society of other types of professionals, for the good of the profession, we should have people who behave ethically or who behave, with good conduct. There's also sort of, I would say, more practical level impacts on doing this and having a code that is enforced and that you talk about. Sometimes there are high profile, whether we like it or not, high profile actions that may be done by a member or somebody else who's affiliated with our organization. And we don't want to have anyone know that or think that they're part of us or that they're a part of our organization. So from our own reputational standpoint, we want to have a process in place to be able to remove these people who might otherwise embarrass the organization. And then there's sort of particularly if you're representing an association, be it a society, professional group, or something like that, you want the reputation of the profession to look good to the eyes of the members of the public. So if you're in a particular profession that may have had some issues in the past with high profile articles about particular professionals, a lot of organizations will gear up their ethics enforcement to show that we're not only improving the profession, but specifically our organization will not tolerate those sorts of behaviors. And also finally, I think it helps to show value of membership, that it actually means something to be a member of this organization, and not everybody can join and stay in. Okay. So a lot of people have and I think practically speaking, I don't know that this is sort of dictionary definition, but as part of the nonprofit community, over time it's been sort of delineated between conduct and ethics. And a lot of times when you see a code of conduct, oftentimes it's directed to, for instance, behavior at a meeting, or behavior at an event or an activity of the organization. Whereas, ethics tends to be a little more focused on how one conducts oneself within the profession itself or within the industry itself. I would say that the trend, to the extent there is one, is that, both types of conduct and ethics are regulated by nonprofit organizations. And I would say anecdotally, given the groups we represent, that for the most part, they are put together these days. I mean, there are a lot of organizations that will have a code of conduct for meetings and then a code of ethics for members generally. But I think the trend is probably to somehow put them together just for, efficiency's sake. But they are two different types of activities that you're regulating. Oftentimes, the ethics side of it is the part that I think that when an organization regulates that can be a little more difficult to regulate for reasons that we'll talk about. From a enforcement standpoint, it's often difficult for an association or other nonprofit to know of unethical behavior in the business context or in the employment context, whereas conduct obviously is often there for you to see because it's right there at your own event or activity.
Well, I think there are gating questions too for what the code of conduct should cover, and does it apply to just programs, meeting, and events that are associated with an organization, or does it extend beyond that into other aspects of professional life, such as on social media?
Right. And that becomes an issue so often with organizations, is where you draw the line as to what the organization really can and should regulate. And it's a more practical question than a legal one, I think. Mm-hmm. But it is a very important one because, particularly in this day and age, there are public statements out there everywhere in social media, some of which may be offensive, some of which just might be someone acting like a jerk, like where do you draw that line? So that is definitely part of what we'll talk about as well, as to how to maybe come up with ways to draw that line. So as I was just saying, there are a couple of things to consider depending on the type of organization you're with, how the organization can establish a code and enforce a code that will regulate conduct in a professional context. And we start with, there are a lot of organizations, I had a look at the list of those who registered beforehand, a lot of organizations represented on the call here, whose members are professionals that are licensed in one way, shape, or form, be it an architect, a doctor, a lawyer. And in those situations, you have a sort of a state overlay of regulation. And to be able to practice as one of those professionals in the state, you have to go through the state licensing body to get that approval. And oftentimes that state licensing body usually will regulate ethics in one way, shape, or form. And so, for the professional society, you kind of, in some instances, in a way, take a backseat, or at least, play a bit of a wait and see when it comes to what happens at those licensing bodies, which have, by the way, far greater resources usually and far greater ability to compel compliance by the licensed individuals, so they will come before the body. They will, there's the ability to investigate that is, much more robust than a private association. So for many reasons, an association whose members are in one of these licensed contexts, may do well to maybe play a bit of that secondary role in allowing licensing agencies to take the first cut. Another point that has come up often is particularly large employers or employers that may be involved in government contracting, that sort of thing. There's a growing attention to ethics in the private employment context, including the offering of ethics hotlines and the ability to, report different, potential violations of a company code of conduct or a company code of ethics through the chain in that company. And oftentimes when that's the case, you're very unlikely as a professional society, membership organization, or other type of group to see or hear of those types of issues. They're handled internally at the company, and for many reasons that are probably pretty obvious, the company won't sort of report that along to a private association or a membership organization or that sort of thing. So to the extent that, you're with an association or a nonprofit that may not hear of many potential violations of a professional nature in the code of ethics area, oftentimes it might be that they're being reported internally or handled internally by the companies.
Yeah. I think it speaks to overlapping jurisdiction, if you will, between government regulatory agencies, individuals, employers, or other nonprofit organizations with whom your organization might be working with to host certain events, programs, and meetings. And there's that gating question of who's responsible and who should be resolving a complaint if a complaint is brought forth.
Yeah, exactly right. And then, so the other side of the equation, I've said this before in speaking to some of our nonprofit organization groups that we represent, oftentimes you get the question is, well, what if we sort of fail to act? What if we have a code of ethics and we require members or purportedly require members to adhere to the code and they don't? What's the liability of the organization if such an individual does not adhere to our code of ethics, code of conduct, remains a member, and then causes harm to some third party? And the general rule is legally, that's very difficult to make a successful argument that the association in that situation is somehow on the hook for liability to that third party. I mean, the general concept in tort law for associations is associations generally are not liable to third parties. Particularly when it comes to someone being a member or not being a member of the association. Now, it can get, with bad facts, it can get to be a concern, it can get to be a risk, particularly if you're involved in certification or providing some sort of, purported blessing or endorsement of a particular individual. Usually that's in the context of certification. And so there is an example of a case that was filed. It was not brought to finality, but the court did allow it to pass through past motion to dismiss, where an individual was a hospital technician who had the association that engaged in the certification was aware of, or there was evidence to show that the association may have been aware of this certified individual's prior misconduct in I think it was in the context of basically abusing hospital pharmaceuticals, and did not move to remove that certification. Another hospital hired this individual and was found, as the slide says, passed out in the restroom with a needle in the person's arm, and so the hospital sued basically for negligence on the part of the certifying body because you were aware of this and you should have taken action. To me, that's a very extreme situation. I almost raise it as a curiosity, but also to say that there are some expectations and obligations and risks on the legal front, but also perhaps more relevant, more likely risks on the reputational front as well.
Yeah, I think not acting, while sometimes complaints can be daunting to address, not acting can elevate those complaints, whether that be internally within your stakeholder communities with members, or with the media and the press, and individuals finding another outlet to report their concerns and complaints, or even going to a state attorney general's office or the IRS to complain about the organization's lack of action to respond to stakeholder complaints.
Excellent points. Yeah. And then the other thing, obviously, when it comes to conduct at meetings, there are risks to an association or other nonprofit organization if you don't take action when you have a credible complaint about someone generally behaving badly, more specifically harassing or otherwise acting in a way that could create employment risk to the organization, obviously, but also risks to the organization if that person is not somehow, if that conduct is not somehow addressed, and then goes to a next meeting and does it again.
Yeah, definitely increased liability risk for willful ignorance and knowledge of the potential for harm to your community.
There are some, obviously, we're two lawyers talking about this. Many of our nonprofit organization clients will come to us on enforcing code of conduct. There are other risks that come into play. And it's very, sort of big picture, both the setting of the standard and the way the standard, be it the code of ethics, code of conduct, whatever you want to call it, the way that reads and what is restricted, could present legal risk, which we'll talk about, but also the way we enforce and how we allow someone or not allow someone to answer to concerns raised also can present legal risk. The other thing just to keep in mind, particularly those of you who advise nonprofits, is there are state law issues we're going to talk a little bit about that govern somewhat the process whereby an individual who's facing potential sanctions must be granted certain processes. Make sure not only that you're consistent with the state law, but also the bylaws are consistent with the state law and your policies and procedures are consistent with both. And as I said earlier, always be mindful of the fact that if there are employment law issues, I would say as a general rule, those take precedent. And so if you've got a code of ethics, and we'll talk about this a little bit, if you've got a code of ethics that purports to regulate the conduct not only of members, volunteers, et cetera, but also staff, make sure that that's handled in a way that first gives attention to the labor and employment side. Obviously there are certain rights and risks that go along on the employment law side that just aren't there with enforcing codes of conduct against members.
Yeah. And on the duty to investigate, while there are sound and well-established investigatory best practices, there's no one-size-fits-all approach for how to approach an investigation, which will largely depend on the unique facts and circumstances that are implicated. But we'll typically see a range of ways to approach investigation, whether that's an investigation that's done entirely internally by an organization, either within a human resources function or an established ethics committee that exists, or with the assistance of an independent fact finder like legal counsel to remove the fact finding from the organization itself, but to a neutral and impartial party.
Right. Great point. I will take this time now to say the CLE code for today's session is Conduct 2023, Conduct 2023.
And well, for those who missed that, we'll announce that code again as well later on in the presentation. But standards and how you actually create the code. And we spoke about a little bit about this in the beginning about what standard are you going to hold an application and who are you going to hold to that standard. There are typically two models that we see, either an aspirational code or an enforceable code. And an aspirational code is essentially a set of suggested expectations for what individuals should do or are encouraged to do, or what might be normative conduct. The enforceable codes, on the other hand, are things that members must do or cannot do. And that phrasing and terminology is very important when it comes time to resolving a complaint about conduct, because what do your rules say in the first instance? Is it just a guideline, and so it's not something that will be enforced, or is it a mandatory compliance code? And thinking through that, what do you want to accomplish? And do you want to be viewed as a standard bearer for suggested practices, or do you want to take on the responsibilities of ensuring that those practices are followed? There's also the scope as to who should be subject to our code. Does it include just members? And when we speak of members, is that individuals or organizations or both? Does it include non-members like attendees, vendors, suppliers, others? As well as, do we have different sets of rules for our certificates and holding individuals who have some type of designation from the organization to a higher bar as part of demonstrating, the value that that certification might have? I think what's important, especially if it's an enforceable code, is to have acknowledgement and agreement to the terms of your code of ethics or code of conduct, and that practically is typically done at the point of membership application or membership renewal or registration for your conferences and events as part of the registration workflow.
Right, and also if you are going to include vendors, then in your vendor agreements as well. And so, right, and I will just point out, I think, as I noted, I think it's far more likely and probably recommended for the certification bodies and those that offer certification to not do simply aspirational. I think with that one, it's more likely to have enforceable as well.
Yeah, and if you have a mandatory code, are you enforcing it, or are you not enforcing it? And do the provisions, they're on the books, but they're not used,
right,
or are they actively
and then you
enforced?
could get, which we'll get to, but you could get an argument that if you do finally start enforcing those, like, are you going to be accused of selectively enforcing and therefore somehow violating some due process rights or otherwise getting ourselves into some legal trouble?
Yeah. Geography is also important in substantively determining what type of guidelines to adopt or restrictions to enforce. I think most organizations follow an equality principle that the code will apply equally regardless of jurisdiction. And it's important that to still recognize, though, that business conduct norms, cultural norms can vary from location to location. And that perhaps speaks to the importance of having an inclusive scope of your membership represented in the enforcement processes that you might use, or the processes to develop what your code is, so that you have input from a variety of communities within your organizations that are representative of the membership that is regulated.
Great.
So in terms of some of the best practices for creating a code or updating it, it's important to remember that it is at core a standard setting process. So it's important that there be consensus development that involves input from individuals who might be affected. So that could be in the way of having a working group or a task force or a committee, the ability to provide comments in writing or orally. It's important to have the code provisions and the procedures for enforcement vetted by staff, as well as other volunteer leaders that are involved. Important to have counsel involved. You don't want to get to the end of your drafting process and a rewriting process that could take a year or two, and then have to make some tweaks. So it's always good to involve counsel at the outset. And the role that counsel plays can be one in the background, an advisory, or a more active role in participating in meetings.
Yeah, And I would say, in terms of, we've seen the gamut, and many of you on the call probably have too, between very broad and vague provisions, that, all members, shall act honestly, or, all members, shall act with respect of others, which are very difficult to enforce at that vague level. But also, I would say you can get too specific on your code provisions as well. It becomes it's not a set of statutes. This is not, you're not establishing law or regulations. So, somewhere between the very detailed and the very vague, high level provisions, to me, are the most effective types of code provisions to be able to enforce, because it does give some flexibility for interpretation by a reasonable committee of people, but by the same token doesn't sort of leave the covered individuals, those who are subject to the code, wondering as to whether they are at risk of violating the code. So there is I think an art to creating code provisions that will be broad enough, but also specific enough to be able to enforce.
Yeah, well, and also understandable and in plain English, so that the terms are actually read by your members and other stakeholders, and that your members can also espouse the rules that are set forth in the code.
And I think when you get to the rules of due process, or you get to that's not just a practical point, it's a legal one too. I mean, one of the requirements to give due process and fair process to individuals facing sanctions is that they're aware of and can sort of understand and comply with what it is they're being held to.
So just along the lines of some of the steps that can be taken and that organizations have taken when updating their codes is to seek feedback from members through a survey, or have a focus group discussion, have some type of volunteer or staff committee that's involved in creating the draft, refining the draft, circulating the draft for comments, having a process in place on how you respond to comments and resolve those comments, and ultimately bringing the document up to the board of directors or the board of trustees or the governing body of the organization for final sign off and approval, and then having a communications plan in place to inform your stakeholders about the new or revised code and what that means, and what the process for submitting complaints might be, or what the process for resolving complaints might be, so that individuals have access to it. I think more and more we're seeing organizations will include a copy of a code of conduct or a code of ethics in meeting brochures and materials, or embedded in the conference or program app that can be easily accessed, just to make sure that it's widely disseminated. Yeah,
that communications aspect is very important to make sure everyone understands what they're covered under. And these steps are, I think, not every organization has sort of the luxury of going through all of these in a very comprehensive way. So I think what this is at least establishes, I think, an example of an organization with resources and commitment from the top to have a focus on ethics. I think this approach, as those of you who engage in standard setting would recognize this as similar to a standard setting process, but understand that different organizations have different resources and time available for this. Okay, now we're going to go through, we talked about the standard, we're over to the procedures now. So this is sort of the second of the two pillars that I talked about. And we'll talk a little bit about how to make your procedures legally sound, but also practically manageable. The idea here is obviously to meet all legal obligations and minimize legal risk for the organization to the extent we can, but by the same token, not have an organization's ethics processes sort of swallow up resources and time beyond that which is sort of reasonably necessary.
Sure. So in terms of, sorry.
That's fine. So we both know this.
Yeah.
So here are the primary legal concepts that come into play when you enforce your code of ethics. I mean, look, probably goes without saying, but what we're doing when we're enforcing a code of ethics is we're telling someone, and oftentimes we're telling more than that person, we're telling maybe our whole association or our board of directors, that a person is not eligible or not ethical enough to be a member of ours, or is not, or has done something unethical and therefore merits some type of sanction. We may be removing a certification. We may be removing something that would be essential or at least helpful for an individual to practice in his or her profession. When we do that, we face legal risk. Whenever an organization does that as to an individual, they face legal risk. That doesn't mean, organizations do a lot of things where there's legal risk, but that's the core issue that we're mostly concerned about. Sort of from the quote from Groucho Marx at the beginning of our presentation. There is a general acceptance, and it was most recently sort of reinforced in a Supreme Court decision not too long ago involving Boy Scouts of America, which is basically an organization has a right to decide who is or is not a member of the organization. So there is this sort of associational right that's part of the First Amendment. Courts have recognized that with some limitations, and obviously we're going to talk about what those are. But you start from the concept that this is, the right of association is protected in the First Amendment. Courts have time and time again have decided cases involving associations that either remove people from membership or otherwise regulate membership activities as saying we will not interfere with the internal affairs of a private nonprofit corporation. That doesn't mean that everything's fair game, nor does it mean that we have a situation where we don't have to worry about all these procedures. There are contours, there are limits. Oftentimes when a court will say that in a decision, we usually will not meddle in the internal affairs of an organization. Oftentimes that may come right after that with a but, or however. In this situation, and those other types of, those other legal concepts that we'll talk about here is our antitrust, potential for defamation. Confidentiality is not really sort of a legal concept, except if we've contractually obligated ourselves to keep something confidential, we have to adhere to that or else we have a contract issue. But probably the biggest issue is what we call due process. And it's mostly common law, but it also has found its way into some statutes.
Yeah. And on the confidentiality front, we often see organizations will overpromise the amount of confidentiality that they can provide in the course of investigation that will keep whatever you say absolutely confidential. So
Right.
just important to be careful about the assurances that are made to complaining parties or to witnesses or to the subject of a complaint about what will be done with the information provided.
Right. Agreed.
One of the important considerations in enforcement is ensuring that there is a record to support the legitimate non-competitive motivations for taking actions under a code of conduct or a code of ethics. Within the last decade, the Federal Trade Commission has pursued enforcement actions against associations that have had overreach in their codes of conduct or codes of ethics. And in a nutshell, the commission was pretty suspicious of rules that didn't allow members of an association to make their own independent business decisions about pricing or where they do business or how they can advertise their services, or that would prevent members from soliciting clients of other members. And so it's really important to avoid having provisions that deal with how members are advertising their services or marketing themselves, that restrict poaching or that will divide up territories or that will limit competition in the marketplace on pricing terms. I think in a nutshell, it's important that your code of conduct or ethics be able to withstand independent scrutiny from a government regulator, and that this just doesn't apply to the larger associations, but the smaller ones too. And the FTC was going after piano teachers and figure skating coaches and small associations of paralegals, property managers, and associations that had small memberships of 300 members to several thousand members. So really the full gamut. There's not you're small exception to antitrust considerations.
Yeah, and in a couple of those instances, the organizations weren't really enforcing those codes very much either. But the existence of the code, one of them said something about, it's unethical to poach our clients from one another, or it's unethical to go into different territories that others have already established, other members have already established. Obviously, antitrust issues with those But in those instances, the associations had not been enforcing them for years. But regardless, having those on the books was enough to get them into some trouble, and they had to do a consent decree. And a couple other things I would say just on this on the antitrust front. There's sort of historically there was a Supreme Court case that involved the National Society of Professional Engineers, where the association had made it an ethical rule that engineering members are not allowed to bid on projects based on price. That any bid on projects that where an RFP has been issued and they're responding to the RFP, those bids, if you're going to be an ethical member of this association, those bids are only to be based on your own experience and not to provide pricing. This was a practice that was not limited to that group. That was the only group that sort of made it up to the Supreme Court. But many learned professions had similar restrictions in the 60s and 70s. And what the Supreme Court decided was there is no such learned profession exception. So, anything that would suggest that, there's an exception out there for different sort of highly specialized types of professions, it's not there anymore. But there is now a Supreme Court case that came out in the 90s that did allow for some regulation of advertising where the particular profession that's doing the advertising has unique knowledge that the individual consumer may not have. So what that got to is, the potential to avoid misleading or deceptive advertising can still be something that's regulated. It has to be very careful if you're doing it under a code of ethics or code of conduct, which often is enforced by members who may be viewed as competitors. So that's something that's out there, but I would say there's certainly a lot of risks that go along with doing that. Other things, you sort of hit this, Andrew, but the way in which you market yourself as a company generally should not be a subject of a code of ethics enforcement. And for instance, an organization whose members may find it unseemly that people go door to door to market their products or services, that in and of itself is probably going to be problematic to regulate. Now, if there are more sort of specific issues related to that type of marketing that show the potential for fraud or deception or coercion, or those sorts of things, maybe you can get to that point. But that's another area that I would advise is of some risk. And then finally, I know with a lot of doctors' organizations, there are issues about ownership of practices and things like that. I will just say very generally that putting those into the ethical context, should be done only, very carefully to make sure that we're not running afoul of any antitrust concerns about how an individual doctor may affiliate himself or herself with a particular practice.
Yeah, and for those licensed and regulated, professions, there are different antitrust considerations that apply to state licensing bodies as well that are different than the antitrust rules that apply to private non-governmental organizations, which generally don't have immunity from antitrust law application. So in terms of defamation, what types of information will an organization share about complaints that it receives or how it resolves them? Generally speaking, putting information out into the ether about an individual's conduct or unethical behavior presents defamation risks, particularly if it's not true. And so this is a tort risk that many different organizations want to be careful with guarding against in terms of the scope of information that is shared and with whom it's shared with. There's always the question about public reporting of the results, as well as reporting back to complaining parties, witnesses, as well as the subject of a complaint themselves. And there's trade-offs in terms of when, how, and why you share information or choose not to share information. And generally is a balancing act between the legal considerations versus the practical considerations of reputational risk, making sure that you have members who participated in a process that they feel was responsive to them, was heard their complaint, was receptive to it, as well as to the subject of a complaint, ensure that it was a fair process as well, and that dirty laundry isn't necessarily being aired. Clients often come to us asking about, what do we do with a complaint we've received and we've resolved it? Do we need to report that finding to an individual's employer? And that's often a tricky situation for organizations to navigate.
Right. And that's what it gets down to when we talk about the confidentiality provisions of your procedures, to make sure that people understand, particularly those facing ethics sanctions, that this information could be made public, could be reported, and so make sure that you've protected yourself on that side. And then, I think there are some judgment calls where an association would rightfully make to either make the reporting in that situation, or oftentimes associations will make it more public, because part of this process is to show that we are enforcing our code and we're not going to let this sort of conduct happen. And so the trade-off is, let's make sure that we've given them a fair process and that we feel comfortable that at the end of the day, this is something that's truthful and a fair sanction. There is a qualified privilege that applies to individuals and organizations that go through these processes. In most states, defamation is a state-by-state animal. It's generally a common law legal concept as well. But most states do recognize that a fair process that may involve many people hearing and talking about conduct of an individual, if that's done fairly and in a way that to the extent confidentiality is needed, it is adhered to, and there's no actual malice, the risk of defamation is lessened because of that qualified privilege.
And not so much defamation, but also consideration around attorney-client communication privilege, the extent counsel has been involved in the resolution of an enforcement matter, being careful about what's disclosed both externally as well as internally to ensure that communication privilege is not waived. So due process considerations, it's really important to check the laws of the state in which you're incorporated as to required processes that might apply. Some states have procedures that are set forth in the statute that must be followed or that should be followed before taking action to suspend or terminate an individual or entity's membership in your organization. For example, California has a process that sets forth procedures that have to be filed to get a presumption that your removal process or your suspension process is fair and reasonable. So there can be benefits to following that statutory process, so that if the action's ever challenged, you're starting with a leg up in that process. It's also important to keep in mind that at the back end of this, that there can be another layer of review externally by a court, and state statutes will often give members the ability to contest their removal or suspension from an organization if an organization's procedures weren't followed, or if there was a due process violation. Additionally, it's important to keep in mind the positions that you're removing individuals from and the different hats that they might wear. The rules for a member of an individual as a member of an organization are different than provisions that apply to removal of an individual from the board or an officer position. Oftentimes, state statutes will require directors to, if they're elected by the members, to only be able to be removed by the members, which could cause a very public vote that would require a large undertaking and effort, which sometimes leads, suggestions to resign to avoid that vote.
Informal process there,
but important to be mindful of state law, check your governing documents, and make sure that your governing documents have a clear removal and suspension process in place.
Yeah, and the other point is I would think twice about trying to apply your code to staff of the organization, understanding that oftentimes when the discussion of the code takes place, it's at the board level, and the board wants senior staff to be right along with the rest of the regulated body. But there's a different set of laws that really are, as I said before, that really should take precedence when it comes to conduct of a staff member, and those, that's the process to take when there is a potential misconduct by a staff member.
Yeah. And in speaking about process, we're really speaking about procedural due process here. We spoke earlier about substantive due process and making sure that the provisions that you're going to enforce are understandable, and put individuals on notice of what they're going to be regulated by. Procedural due process speaks to the fairness and consistency in the way in which you enforce your code. And generally, due process consists of a few elements, including notice of the alleged wrongdoing, the ability to respond to that wrongdoing, whether in the form of a hearing that can be in writing or orally in a live hearing, that an individual has access to information that will allow them to present a defense, essentially, understanding who's made accusations against them and what information has been presented, ensuring that the decision-making body for making factual findings are impartial and don't have conflicts of interest, that the weight of the evidence is substantial enough to, by preponderance of the evidence, more likely than not, that the alleged infraction occurred. Nonprofit organizations, it's not a criminal trial, it's not a court of law, so you're not subject to that, beyond a reasonable doubt threshold, but it's important to have a threshold articulated in your procedures and understanding that generally the hearings and the procedures that are required don't rise to the same level as a true judicial proceeding.
Right.
And in terms of the punishment that might be meted out, to have progressive discipline ranging from a warning or probation or suspension all the way up through expulsion. But there has to be proportionality to the conduct and the infraction, as well as consistency across similar cases as to you have two similar circumstances, you should be applying similar types of sanctions and not having different outcomes. And then lastly, an appeal, whether to have one, generally not considered a right of due process in the associational context. But is your organization going to provide a voluntary appeal right? And if so, what does that look like? Is it up to the board or to another committee, or do you not have an appeal right and effectively let judicial review externally be that appeal right to contest the organization's decision?
Right. Yep. Agreed. So getting those are the legal concepts that really, when we advise and we help create procedures and when we help create codes of conduct and codes of ethics, those are the concepts we're looking to. And those of you who also advise, you should be looking to those as well. It's obviously, it's a bit of an issue spotting, not just one body of law to worry about, but different things. But when it comes to some of the practical points now, to sort of shift gears a little bit, how do we make sure that we adhere to the due process requirements and we manage those other risks without making it too burdensome a process for staff or for the volunteers who are running it? Some groups will, these are questions to answer. There's no right answer necessarily. I will say, some groups we work with will say only members can file a complaint. I would say prevailing trend is to allow anyone, to submit a complaint, not just members. Because it could be someone who's not a member of the organization who's harmed by that individual who is, it was in the context of their profession, it was in their context that it was covered under the code, and nonetheless that person's not a member. So I would say that the trend tends to be more towards allowing more than just members to complain. One thing that is, I think most groups adhere to now from a practical perspective, is creating some sort of form or some sort of minimum required information to kick off a process where a volunteer body or staff is going to be asked to either investigate or consider investigating. And some level of detail, I think, is important. You're not going to have everything there in that form, and the volunteer committee or the staff that's doing the investigation is going to need to find out more information. But some level of detail as a threshold matter, I think, will help manage the process and in a way to make it more efficient and to avoid those, emails that are shot off in the middle of the night from somebody who's just ticked off about something someone else did to them, where maybe in the light of day they would think twice. And making them fill out that form and present some detail may allow those people to have that moment of reflection where it might get rid of some of those more frivolous and vexatious complaints.
Yeah, and it also affords an opportunity to include a certification for an individual completing the form that they're testing that the information they're providing is true. And that can help, having an individual stand behind that attestation adds some gravity to the completion of the form before the organization will go forth and devote resources to resolving the complaint.
Excellent point. I agree. So some other thoughts again about, let's be as efficient as possible. Let's be effective and meet our legal obligations. There are, we work with a lot of groups that have these codes of conduct. And I think across the board, there are situations where you get complaints that just aren't ready for prime time. They're not really complaints about an ethical violation. They are perhaps, for these other reasons that maybe got put into the wrong bucket. Maybe they just, shouldn't be dealt with at all by the organization. But I think it's important for our rules to make clear, for example, that if there's a concern about a policy decision by an organization, the organization has decided to endorse this particular piece of legislation, for instance, that's not unethical. That's not an ethical issue that you can bring the board before an ethics body for. So it's important to make sure that our documents make clear about those sorts of things. I also get a lot of complaints that I would say are mostly interbusiness disputes or interpersonal complaints. And it's hard to draw the line as to where exactly that is. But I think even to put that into the mind of the people making that decision, or those that are considering filing complaints, that these are not for us. A contract interpretation is really not where an ethics committee should be. A matter of, and this is, some of these examples will be slightly changed to protect the people we work with and certainly are anonymous. But one example not too long ago is the context of the complaint was largely one individual was having a long-standing dispute with a neighbor over things like their fence, how they keep up their lawn, things like that. And the complainant found out that the respondent in that situation happened to be a member or certified by the organization we work with. So clearly not the highest and best use of an ethics committee to deal with that. Other ones, some groups will not allow anonymous complaints. We can talk a little bit about that. Obviously, under the due process right, an individual has a right to understand what the sort of the factual situation is that they are alleged to have engaged in, what the conduct was they're alleged to have engaged in. And for a person to be anonymous, it makes it very difficult in many situations for that respondent to have fair process. Now, some groups may make judgment calls and say, okay, well, if an anonymous complaint comes to us and we can independently verify that complaint and not rely on the anonymous complainant's assertions, but rather on documents, other witnesses who will come forward and those sorts of things, we will go forward. Other groups, it's sort of with an eye towards the resources and what's the best way to administer a program may just say, it's not worth it. It's difficult to make that judgment call to begin with. Finally, and these are all, as I say at the top here, early rejection opportunities, ways to say, okay, we're not going to pursue investigation on this front. If there is another legal proceeding, particularly we talked about the licensing authorities, but obviously there could be civil litigation, there could be, criminal either charges or investigations going on. It's difficult to find out sometimes whether criminal investigation is going on. But if you are aware of those other proceedings, it's generally advisable in my mind to have the organization delay at least consideration of the complaint and let these other processes where there is the ability to, force a subpoena, to do, compel people to testify and things like that, to allow that to play out. And then and only then does the organization consider whether to go forward with it. And then another way to sort of potentially have an early rejection would be just to decide, would a proven complaint constitute a code violation? So like I said, you have a form, you're not going to get everything that you're hoping for, but if what's alleged is simply not going to be a violation, if the allegation is, so-and-so looked at me wrong or something like that, obviously, even if proven, that's not an ethics violation. And similarly, is what's being alleged something that's just almost impossible to find proof for? Maybe the allegation is something that happened very long ago, or it's something that's based on very difficult to obtain information. Those are reasons to dismiss early or reject. Okay. Other things to consider when you're drafting your procedures or honing them and creating some maybe improvements to your procedures. Timing considerations, the length of a process often depends on how long one is given to respond. In my experience, in most ethics cases, someone who receives notice of a complaint and is asked to respond Either we'll do so within a day or two of getting the complaint, or within a day or two of the deadline. So, so I think that length of time, you should take that into consideration. And would we also hold others to the deadline, like the own committee? And what about third parties? How long do we ask them before they come to us with responses? And then, other decision-making thresholds and things like that are important to consider when forming the procedures. We're getting low on time, so I'll keep moving quickly. Sure. And these are other things to consider and to address in your procedures. What if someone resigns mid-consideration? You know what? Rather than face this tribunal or ethics proceeding, I'm going to just quit. Many times an organization would say, okay, we no longer cover these people. This people is no longer sort of under our jurisdiction. By the same token, you could have a provision that says we will continue to consider this, and that will affect your ability to rejoin the organization, for instance. And how do we address failures to cooperate? A lot of times people will sort of ignore or hope it goes the other way. One thing I will say quickly, when we talk about the procedures generally, is be careful not to be too strictive and adherent to the letter of the procedures. So very often the notice to the respondent, you may not get a response at all. And when that happens, it could be that the respondent's ignoring. It could also be that you have the wrong address. You have the wrong email address. Something has changed. Now, it's important to include in your procedures some affirmative provisions that says it's your responsibility as a member to maintain the right contact information with the organization. But at the end of the day, it's a risky move to take action based on a failure to respond if you don't take other steps, practically speaking, to make sure that this person has received your notice. And of course, conflicts of interest are very important to address to make sure that the organization's committee that is considering this are made up of people who do not have a conflict of interest as the individual. Now, with associations, oftentimes you will have people who know one another, or maybe, in ways compete with one another. So there are some judgment calls to be made. Otherwise, in a very broad context, arguably there's conflicts of interest around every corner.
Yeah, and sometimes like overstatement of conflicts of interest just because two individuals know each other based on their membership in an organization doesn't necessarily preclude that individual from participating in decision making around an ethics complaint.
Agreed. Yes. Do we give a right of appeal? And generally, what we've seen with most states is that's not a mandatory requirement. It's not been cited in court decisions as necessary in a private association context. As we said before, basically the individual's right to appeal may be through the courts to begin with. But sometimes, and oftentimes, we will advise having some limited appeal, right? Yeah. Where it has to do with some clearly erroneous standard, or perhaps something that happened procedurally wrong. And sometimes you may have actually a provision that says if there are facts that come out that weren't available at the time of the consideration by the trial level body, that would be dispositive, or that could change the consideration, that maybe that's a reason to take a second look. If so, make sure that the appeals body is separate from the body that made the initial decision. Also, make sure if you do allow for an appeal, there is this isn't a second trial. This is just on the limited rights of appeal that you would give. And finally, I can't say this strongly enough, do not allow a complainant to have a right to appeal. This isn't a business dispute. This isn't an arbitration. This is an ethics process. So although the complainants may not always be happy with the end result, it's important not to allow that appeal.
Yeah. We spoke a little bit earlier about the progressive discipline and range of sanctions. And I know we're short on time, but this is the final point that I would make here in terms of how you capture your findings as well as the sanction information is always write for a different audience, and keep that in mind. You're telling a story potentially to third parties that might have access to the information that you're putting together, such as in some subsequent appeal in judicial review, or if a responding party leaks the findings because they're dissatisfied with the results. So generally, not being overly emotional, being generally factual and to the point and concise are good, and being objective are good and important considerations to keep in mind when preparing the record of what occurred what was alleged to have occurred and what the findings were.
And although I know sometimes it's compelling to do so, and I know a lot of groups do it, I say be careful with specific performance requirements. I mean, sometimes when you have a decision and you find a violation and it's okay, we'll give you a private reprimand or a warning, but we also want you to take this ethics course, or we want you to apologize to the person, for instance. If that's going to be part of your sanctions regime, make sure that you have the capacity to follow up on that and then take action if the person doesn't do it. You create sort of a tail obligation to keep monitoring that situation when you have that part of the sanction. So on a very practical level, I point that out. And I think we've ended our show. So we're a little bit more than out of time, just a couple minutes past though. What we'll do, I guess, is end this here. We'll look over at any Q&As in the chat that have come up and get back over the week to answer any questions. Appreciate your time listening to us today. Again, the code for the CLE is conduct 2023. Thank you for your expertise and time, Andrew, and thank you all for listening to us today. And as I said, we'll follow up on the Q&A that we have.
Great. Thank you for a great conversation. Thank you for joining us, everyone. Enjoy the rest of your day.